Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to County Court at Law Number 2 today because you have a case in this court. In County Court at Law Number 2, we handle criminal cases. The type of criminal cases that we handle are misdemeanor cases. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your most serious type of offenses, whereas your misdemeanor offenses are normally referred to as your petty offenses. It doesn't mean that they are not serious. It just means that they're not as serious as a felony offense. And when I use the word serious, what I'm talking about the facts of the case or the circumstances and the punishment that a person can get if they are convicted for committing the offense. If you have a felony offense, felonies are divided into 5 categories. You have the capital murder, which is the highest, and then we start going down to the first-degree felony, the second-degree felony, the third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months in the state jail to a maximum of 2 years, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment, minimum 2 years to a maximum of 10 years in the state penitentiary, a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment, minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum to 99 years in the state penitentiary or life, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony offense, which is a capital murder, the range of punishment, if convicted, is life without parole in the state penitentiary or death by lethal injection. Now, as I mentioned earlier, the type of case that you have in this court is not a felony case. It is a misdemeanor case. Misdemeanors are divided into 3 categories, and we'll start at the top. You have a Class A misdemeanor, then we come down to Class B, then the lowest misdemeanor is a Class C. If a person is convicted, now your Class C misdemeanors are normally those misdemeanor cases in the JP court, Justice Court, or the city court, which is a municipal court. For example, speeding ticket. Person is speeding, that's a Class C misdemeanor, not wearing a seatbelt, Class C misdemeanor. And so there are a whole list of Class C misdemeanors. Those cases come to this court when a person appeal their conviction from the JP court or the city court. And then it comes here. The range of punishment does not change. And the range of punishment for a Class C misdemeanor is fine only. Therefore, you only could be given a fine for a Class C misdemeanor. However, if you cannot pay the fine, or if you fail to do community service, then your fine, community service, can be converted to what we call a capious pro fine. Capious means it's a warrant, pro fine for a fine. In essence, a warrant will be issued for your arrest because you failed to pay the fine. And then you would either have to pay the fine or sit out the time. And you get $100 per day for every day that you sit in jail. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor if a person is convicted is minimum 0 days to a maximum of 180 days, which is 6 months, in the county jail. And a fine that does not exceed, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year, in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, as the defendant in a criminal case, you have rights. And we're going to go over some of the rights that you have as a defendant in a criminal case. Now, the paperwork that has been handed out talks about one right that you have. And one of the rights that you have is you have a right to have an attorney. Now, if you cannot afford to hire an attorney, well, let me do this here. Now, you have a right to have an attorney, and regarding your right to have an attorney, you have three options. One option is you have a right to hire your own attorney. That's number one. Number two, if you cannot afford to hire an attorney, then you also have a right to have an attorney appointed to represent you. Or number three, you can waive your right to have an attorney. In essence, you can give up your right. That's what waiver means. You can give up your right to have an attorney to represent you, and you can represent yourself. And if you represent yourself, then we call that pro se representation. Now, the other thing is, if you want to hire an attorney, your case will be reset to give you time to do so. If you want an attorney to represent you, but you do not have enough money to hire an attorney, you can request that an attorney be appointed to represent you. However, first of all, you would have to fill out a document. It's a financial questionnaire. On that clipboard, it is titled Jefferson County Affidavit of Indigence. You would have to fill out that form, and you'd have to fill out the first page and 2/3 of the second page, the bottom portion of that second page, if it's in order. But there's a page, sometimes it's not in order, and sometimes the page that I'm talking about, which should be the second page, it may be the third page. It asks for you, is the page at the top left, it'll say defendant's signature. It asks for the day's date, and then you have to fill out what is called an unsworn affidavit. That's the second page that you'd have to fill out. Now, if you want to waive your right to an attorney and represent yourself, then if that's the case, then you would have to fill out another form that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. That's for individuals who will be giving up their right to have an attorney and they want to represent themselves. You'd have to read and sign that document. Also, if you waive your right to have an attorney, that is, you give up your right to have an attorney and you decide to represent yourself, then you can change your mind at any time. And if you change your mind, you can request that an attorney be appointed to represent you. Now, you should be mindful that there are dangers and disadvantages of self-representation. Waiving yourself for an attorney and representing yourself may result in a worse outcome for you, including the loss of significant legal rights. First of all, one of the rights that you have that you can lose is right to possess, obtain a firearm. You may lose your right to have custody of children. It may affect your employment. It may affect your ability to get housing and public assistance. And it may affect you getting employment, or if you're not a U.S. citizen, it may affect your status as a citizen in this country. Now, at the bottom of that document, there are 5 lines to the left. If your choice is to reset your case to hire an attorney, you will place your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney or give up your right to have an attorney to represent you, and you want to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name at the bottom of the document on the line that is titled defendant, and you will date it today's date on the line that is titled date. And today's date is August 8th of 2023. Now, for those of you who will be waiving your right to an attorney and representing yourself, then you will have to go to the form that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, you would have to read that document, and basically what the document is saying is that you were informed of your right to have an attorney. The court informed you of the dangers and disadvantages of having an attorney, and you know that you have a right to have an attorney. However, you're waiving your right or giving up your right to have an attorney, knowing the disadvantages, and you would like to basically represent yourself. And you'll be, and you're saying that your waiver is intelligently and voluntarily made. And so in essence, nobody is forcing you to do this. You're doing it under your own free will, and you know what you're doing. And so you need to read that document before you sign it, for those of you who will be desiring to represent yourself. Now, the other thing, the other right that you have a right to have a trial by jury. That's you have a constitutional right to have a trial by jury. And what that means is you have a right to have your case tried before a jury. When those young people are sitting in that area, we call that the jury box. Now, 6 citizens from Jefferson County will be selected to sit on your case, and they will decide after listening to all the evidence whether or not you are guilty or innocent. Now, you have a right that you can waive or give up your right to have a trial by jury, and by doing so, you will not be having a trial by jury. However, your case still will come before the court in one of 3 ways. One of the ways that it can come before the court is by way of a bench trial, by way of a trial. A bench trial is a trial by judge only. And if you have a trial by judge only, that means the judge will listen to all of the evidence, and after listening to the evidence, the judge will decide whether or not you're guilty or innocent. That's different from a jury trial, because with a jury trial, the jury will listen to all of the evidence, And after they listen to all of the evidence and the arguments, they will deliberate and they will decide whether or not you're guilty or innocent. But if you waive your right to have a jury trial, your case will come before the court or before the judge, and the judge will listen to all of the evidence and the arguments, and the judge will decide whether or not you're guilty or not guilty. You also have a right to have what we call an agreed plea bargain. That is, what a plea bargain is, it's an agreement that you work out with the state. In essence, you and your attorney will meet with the state to see if you can work out a negotiation or to see if you can negotiate to settle your case. Now, if you are able to reach a settlement, we call that an agreed plea bargain. The agreed plea bargain will come before the judge or before the court. And then the judge can either accept or reject the plea bargain agreement. If the judge accepts the plea bargain agreement, that's fine. Then whatever agreement that you made, the judge is going to go along with it. Now, if the judge rejects the plea bargain agreement, that means that the judge is not going to go along with the plea bargain that you have entered into with the state. Now, if the judge rejects your plea bargain agreement, at that point, you have a right to take your plea back. You can withdraw your plea, in essence. For example, let's say you and the state has worked out a plea bargain agreement, and they're agreeing to give you probation on a case. And the judge says, well, I'm not going to go along with that plea bargain agreement. Then you say, well, judge, I withdraw, I take back my plea. And so if you withdraw, take back your plea, you go back to what we call square one. It's like nothing ever happened. So you don't have a plea bargain agreement. And so you still can proceed with your trial or maybe enter into another plea bargain agreement. The other thing is, if the judge follows your plea bargain agreement and you decide that, oh, you know what, I think I've been wrongfully convicted or the court committed an error by convicting me and I want to appeal my case. If you want to appeal your case, then you have to get permission from the judge that followed the plea bargain agreement. And you have to do that within 30 days. And if the judge gives you permission, then your case will go to another court. It will go up to the Ninth Court of Appeals, which is located right above us on the 3rd floor. They will review your case. They will see whether or not an error was committed by convicting you or whether or not you were wrongfully convicted. They could either grant or deny your appeal. If they grant your appeal, then they could simply find you not guilty and the case is over. Or if they deny or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, you can appeal it to a higher court than the Ninth Court of Appeals. You could appeal it to the highest criminal court in the state of Texas. And the highest criminal court in the state of Texas is called the Texas Court of Criminal Appeals, and they're located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means you'll be doing it on your own without a lawyer, and you'll be petitioning the Texas Court of Criminal Appeals to review your case, to see whether or not your appeal should have been granted, whether or not you was wrongfully convicted, or whether or not this court committed an error by convicting you. They could either grant or deny your petition. If they grant your petition, they can just simply find you not guilty, or they could send the case back to the Court of Criminal Appeals, or they could send the case back down to this court and order this court to give you a whole new trial. Now, the other thing is, if they deny your appeal, that is, they did not grant your appeal, they did not send the case, they did not find you not guilty, they did not send the case back to the Ninth Court of Appeals or send it back to this court. If they deny your petition, then at that point, your petition will stand. The other right that you have a right to have an unagreed plea bargain agreement. And what that means is You and the state have not been able to reach an agreement, however you want your case settled. And so what happens in that instance, your case comes before the court, and the court will assess your punishment. Now, it's not agreement. You don't know what you're going to get ahead of time. And the court will assess your punishment within the punishment range. Okay, if you're within the punishment range, if you have a class B or class A or class C. Okay, now you also have a right to have witnesses to come to court to testify for you. Witnesses, they sit in that chair where the microphone is. We call that the witness stand. And what witnesses do, they can testify either for you or against you. If you're representing yourself, or if you're being represented by an attorney, your attorney could ask a question. If you're representing yourself, you can ask a question. We either call that direct examination or cross-examination. You can waive, which means give up your right to have witnesses to come to court. Now, if you waive your right to have witnesses to come to court to testify in your case, that means that you will not be calling witnesses. It does not mean that the state or the district attorney's office will not be calling witnesses, because they will be calling witnesses. Now, you also have a Fifth Amendment right against self-incrimination. I know at times you may have heard the phrase, people say, I take the fifth. That just simply means you have a right not to testify in your case. The state of Texas cannot force you to take the witness stand to testify. You have a right not to testify in your case. However, you can waive or give up your Fifth Amendment right against self-incrimination. If you give up or waive your Fifth Amendment right against self-incrimination, that simply means that you will be testifying in your case. Now, you also have a right to have discovery. Discovery means you have a right to see the evidence that the state will be using against you, or the state has against you. I like to say this: you have a right to discover or see what the state has. Now, one of you have a right to see the documents that they have. You have a right to see reports, police reports, etc. Other reports that they may be using. You have a right to see witness statements, your statement. You have a right to have access to audio recordings, video recordings, instruments that they may be using, any evidence that they have. You have a right to have access to that information. And now, you also have a right to waive or give up your right to have discovery. That means that you'll be waiving or giving up your right to have access to the information that you're entitled to get pursuant to 39.14 of the Texas Code of Criminal Procedures. Now, everyone here today, you're here today because you was in jail and you bonded out of jail. You're out on a cash bond. That means you paid the full amount of the cash to get out of jail. You're out on a surety bond. That means that you paid a bondsman a percentage of the bond to get out of jail. Or you're out on a PR or a personal recognizance bond. That means you did not have to pay any money to get out of jail. You were released under your own personal recognizance. Every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you've been in jail, you spent 5 days in jail and you bonded out. And now you're an attorney, or you're in the district attorney's office are negotiating, and you enter into a plea bargain agreement. And the agreement is for you to serve 5 days in jail. What that means is you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. If they are offering you 7 days in jail and you've served 5, that means you would only have to serve 2 days in jail because you already have credit for 5 days. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. Every day that you spent in jail, you will be credited at $100 per day. So if you spent 5 days in jail, that's $500 that will be credited toward your fine and your court costs. If you're in the state has reached a plea bargaining agreement for you to pay a fine and court cost of $500. That means you will not have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, your fine and court costs will be taxed and retired, which means you will not have to pay it. Now, if they're offering you fine and court costs of $700, that simply means you will only have to pay $200 because you have $500 credited toward the $700. And so you only have $200 left, and you will be required to pay the $200. Now, if you cannot pay the $200, then we can put you on what is called a payment plan. You could pay it off in monthly installments. And if you cannot pay it off, and if you cannot pay it off in monthly installments, then we can convert the remaining balance to community service. And every hour of community service that you perform in a nonprofit organization in our county or in the Jefferson County area, the Golden Triangle area, then you will receive $12.50 that will go toward your fine and court costs. So, for example, if you work 8 hours a day of community service in one day, that's $100. So in the scenario that I just gave, if you have to pay $200 and the $200 you can't pay it, we converted to fine and court costs, you would have to work 16 hours of community service, and that would be equivalent to $200 that will go towards your payment of your fine and your court costs. All right. Now, Jefferson County has a program for first-time offenders. The program is called pretrial diversion. With pretrial diversion, they will dismiss your case, and you can get it expunged, which means erased, deleted, or wiped off from your criminal record. In order to qualify for the program, it has to be your first offense. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest, and you'll have to have an attorney to assist you with filing an application with the district attorney's office. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has another program that is called Veterans Court. It is also part of the pretrial diversion program. With that program, you get into the program, you complete the program, they dismiss the case, and if you get the case dismissed, you could get what is called a non-disclosure. And a non-disclosure basically means that it's on your record, but we cannot disclose that fact to the general public. The government can have access, government agencies, police departments, but the general public cannot have access to that. So, and most jobs that individuals have are in the general public. Okay, you'll be able to get a non-disclosure. Now, in order to qualify for Veterans Court, you just have to be a veteran of any one of the branches of the United States military. Now, this court, Jefferson County Court at Law Number 2, has a program that is called, Jefferson County Court at Law Number 2 has a program that is called the CSI program, stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office, which was in March of 2017. So it's been 6 years since we've been using and since we've had this program. Program has helped hundreds, maybe hundreds of people. The way the program works is we have partnerships with our local agencies. The young people that I introduced to you earlier, or who was in the jury box, they were with Spindletop. Spindletop is one of the agencies, is our local mental health center. With Spindletop, they're here. They can do a private interview. Spindletop can do an assessment. They can also develop a treatment plan, either outpatient or inpatient, to address mental health needs. Now, individuals don't have to be incompetent or insane to participate in the program. They could be simply suffering from depression, bipolar, schizophrenia, anxiety, post-traumatic stress, a whole host of other mental illnesses, Spindletop will be able to address those for you. Now, Spindletop also has a program that is called ATAR, and our local drug and alcohol council has a program that is called OZAR. Both of those programs are recovery programs for individuals who have problems with drugs or alcohol. And the way the program works is they can do a screening, an assessment, and they can develop a treatment plan, and you could be referred for treatment, either outpatient or inpatient treatment. If you are unemployed, do not have a job, looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program in the hotel industry, the shipping industry, and the chemical industry. Once an individual is trained in one of the areas that they select, then they will assist them at getting a job in the area that they're trained in. Now, if individuals do not have a high school diploma, CICE has a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned are free. It does not cost you anything. Only thing it costs you is time. And in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And by producing productive people, we not only produce productive people, but the individuals are benefited, the families are benefited, and our community is benefited from us producing productive people. And so I tell people this all the time: when you come to County Court at Law Number 2 in Jefferson County, Texas, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we're trying to make a difference with their families, and we're trying to make a difference in the community in which we live. And so all of these programs, as I mentioned, are free, does not cost you anything but time to make yourself better, make your family better, and make our community better. Now, I mentioned to you earlier that we have some individuals here from Spindletop. We have Gabby and we have Deputy Hinton. They're going to come to you now and tell you something about the program that Spindletop has to offer. Gabby and Deputy Hinton. You're welcome.
Morning. Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the sheriff's department. I'm here with my co-worker Gabby. Gabby is a qualified mental health professional. The reason we are both here today is because the judge has graciously invited us in his courtroom because he cares about every single person who comes before the bench. What the judge has found, and this is proved, is those who have legal issues commonly have mental health, abuse disorders, or sometimes lack of community research.
So what we're looking by, with regard like anxiety and stuff, it can be just regular anxiety. It doesn't have to be anything major. It can be the anxiety, lack of support in your life also, or if you have any need for us, this is where you share it for us. And it doesn't have to be anything major. It could just be involvement. If you need somebody here for you while you're in court, or you need support outside because this is a stressful process now. So we're here to provide anything that we can to help.
Now, maybe this is your first time to be here, maybe it's your 10th time to be here. There's still hope. The program actually has the ability to change your life, but we're going to need something from each of you. If this applies to you, we're going to need you to share that need with us so that we can best figure out how to serve you and advocate for you. And Gabby's going to explain that document that I passed out to y'all when I first came in. She's going to explain how y'all can privately share that need with us.
So this serves as a baseline HIPAA consent, which this is gonna be protected just like the medical records are. The only people who are gonna see it is me, Deputy Hinton, and our coworker Chris, who are the two people who are gonna contact you. So this doesn't go outside of our hands. So this, all you're gonna do is put your name, number, and the need that you want. We really need you to please document that on here, because that's the only way we're gonna know. We're actually gonna get in contact with you. The only, the way this document is set up, this allows us to just contact you once, in the matter of you choosing, it can be text or call. Either one, whatever works for you. It just allows us to contact you once, and if you don't want to be contacted after that, is totally fine. We're not gonna blow up the phone. The only people you're gonna really hear from is me and my coworker Chris. If you would like to keep in contact with us, you can express that during the phone call or the text message also.
Also, I have a flyer here for you. I'm gonna give it and put it in everyone's hand before you leave here today. On the back, it tells you a little bit about the advantages of the court program, but also on the front, it has a 1-800 number. Should you ever find yourself in an unsafe place, you can always call that number and get help. Thank you very much. Thank you, Your Honor.
Thank you, Deputy Hinton, and thank you, Gabby. Now, ladies and gentlemen, the paperwork that you have in your hand, we're gonna have, if you need any assistance with filling out the paperwork, we have our court personnel who's here, who will be happy to assist you at filling the paperwork. Just simply raise your hand when we ask if you need any assistance, and we'll have someone to assist you at filling out the paperwork. Now, it's gonna take us a few minutes to get the paperwork, and then once we get the paperwork from you, we're gonna call you up to the bench one at a time. And there is a mark on the floor. We used to have some tape, but it's still, you can still see an X mark in front of the bench. You're gonna stand on the X, and then at that point, we'll go over the paperwork. And once we finish going over the paperwork, you'll be excused from your case here today. Okay? Now, if you need to use the restroom, there's some restrooms right outside of this courtroom in the hall to the right. In front, both restrooms are to the right. The male restroom is in front of County Court at Law number 3. The female restroom is on the opposite side of the hall in front of District Court, the 172nd District Court. Okay. Now, at this time, the court is going to be in recess to give us time to go over the paperwork. And then once we finish the paperwork, going over the paperwork, we're going to ask you to come up before the bench one at a time. So the court will be in recess.